Viewers and subscribers, Dancehall Critics, they are once again, people. Respect and manners to everybody who always tune into the channel. If it's the first time tuning into the channel, please remember to subscribe to the channel and of course, ring the bell icon. That are the only way you'll be a part of the people and will get it first. Or then are the first batch of people will get my content them when them drop. You understand me? So ring the bell icon and subscribe. And while you're at it, people, make sure you go over your IG and of course follow Dancehall Critics over there. So today I talk about a little situation on my here happened with Mavado being sued by a promoter in a Uganda. We'll talk about that, so stay tuned, people. Wagwan people. Welcome again to another discussion on Dancehall Critics YouTube channel. Make sure you say already subscribe and of course share out the thing and tell everybody so you need to subscribe to Dancehall Critics and listen to my discussion them. Today like I said, I'm going to talk about Mavado situation, of course. Situation where he is being sued by a Ugandan promoter. Here the article that I found that I'll be reading from here, viewers and subscribers, is from Dancehall Mag. And it titles, Ugandan promoter moves for a summary judgment in lawsuit against Mavado over failed concert. And right after bat, people, is it the artist's responsibility if the concert failed, especially if the artist went there and did exactly what they needed to do? Who is to be blamed in that regard? What about the promoter? Where does the promoter take blame? But we'll get into the argument here. Last month, Ugandan show promoter Chindu Akira of CC Entertainment Limited moved for summary judgment in a 2019 lawsuit filed against Jamaican dancehall superstar Mavado over his non-performance at a concert in East Africa, in the East African country in December of 2012. So this go far back though, John, my brother. According to the court documents obtained by Dancehall Mag, Akira has alleged that he lost $350,000 seen from the whole affair, which includes $60,000 that he allegedly paid to Mavado, an additional $40,000 he allegedly paid to Mavado's rep for travel, security, and accommodation expenses, and at least $250,000 in damages from concert expenses and the losses of two properties that the promoter said he had mortgages to finance the concert. The promoter is seeking at least $545,000 in lost revenue from ticket sales and at least $110,000 allegedly paid to Mavado or otherwise spent directly on his behalf. On May 9th of 2022, CC Entertainment's attorney Theodore Giga, PLLC, informed the New York court, where the matter is being heard, of course, that they had served Mavado's lawyer, Adelman Matz, PC, and Sarah M. Matz with a motion for summary judgment in the lawsuit. Mavado's attorney have since promised to formally respond to the motion by June 20 of 2022. While CC's attorneys will apply to their opposition to the motion by July 8 of 2022, the Judge Honorable Margot K. Brody will thereafter make a decision on the motion. Why is Mavado being sued? In 2019, CC Entertainment had initially sued Mavado along with VP Records via its subsidiary Reggae Planet, which served as a booking agent for So Special DJ. In the event's contract dated dated July 12 of 2012, signed by Neil Robertson of VP Records and Chindu Akira, Mavado was booked to perform in Kampala on December 29th of 2012. The Ugandan also alleges that Mavado's now ex-manager Julian Johnson Griffith coordinated with him and provided passports for the Father God artist for Mavado and his entourage. So flights could be booked for them. and that Mavado did a promotional video for the event and advertised the show on Twitter and other social media platforms. However, Mavado did not perform at the show, nor did he perform, of course, on March 29, 2013, the alternative date. The Ugandan subsequently sued Mavado and VP for breach of contract and leveled a fraud claim against VP, which is now dismissed. After Mavado denied that Reggae Planet was acting on his behalf, as the company had no authority to bind him. Mavado also caught up in another legal battle against his former Jamaican attorney at law, Jennifer Mavado. She is accused of defrauding the DJ, whose real name is David Brooks, of more than 30 million Jamaican dollars, approximately 194,000 USD, in 2018. That trial is set to begin September 12 of 2022, and Mavado will reportedly make his testimony via link from US. So him now come to Jamaica. VP clears its name. In the CC Entertainment lawsuit, VP Records is not subjected to the outcome of the recent motion of summary judgment. In attempting to clear their name, its name, invalidate, of course, Mavado's denial that they were legally contracted to be his agent, VP had, among others, submitted as evidence the artist promotional video for the show, which was part of the agreement once 50% of the performance 50% of the performance fee was paid. When Brooks failed to perform in Uganda as scheduled, the reason given was not that VP lacked authority to bind him. The reason given was that Brooks had another concert in Nigeria, scheduled in Nigeria a few days prior to the Ugandan concert, and the Nigerian promoter failed to pay him for the Nigerian concert. Brooks decided to cancel everything in Africa, VP's attorney Daniel J. Aaron stated in his motion to dismiss the suit against the label. VP also pointed out that Mavado apologized on Twitter for missing the December 2012 date, agreed to do a makeup concert date in March of 2013, and also did another promotional video. On September 30, 2020, Judge Brody dismissed the fraud claim against VP and also discharged VP Records from the case. These allegations all support the inference that not only did VP Records have the authority to bind Brooks when it entered into the performance agreement, but that Brooks, by his conduct, also confirmed that it did not took the necessary steps to fly to Uganda to perform, including providing his passport to plaintiff to book his flight. The judge had noted Mavado's defense. On April 12 this year, in a pre-motion letter, Mavado's attorney wrote to the judge, asserting their motion that the motion for summary judgment will be denied. The attorney said that there are numerous disputed issues of fact that preclude granting a summary judgment against Mavado. The lawyers argued that the plaintiff cannot establish that a valid agreement existed or that the terms of same were encompassed in the purported performance agreement. To the contrary of plaintiff's implication, there is a genuine dispute as to whether the performance agreement was ever agreed to by Mr. Brooks and whether he can be bound to the alleged terms thereof. The undisputed evidence here demonstrates that the time VP Records signed the performance agreement, VP Records no longer had any formal relationship with Mr. Brooks and had no written agreements providing with any authority to act on his behalf, the lawyer stated. The lawyers also argued that VP Records' alleged witness gave what is at best speculative testimony that lacks any competency and which may not be admissible at trial. Even if such testimony would be admissible at trial, the reasonable fact finder could certainly find testimony to lack credibility and thus find in defendant's favor. Additionally, testimony that Brooks agreed to do a show in Uganda, or a Uganda show, while perhaps sufficient to suggest some alleged understanding, does not show that Brooks agreed to be bound by the performance agreement or that the understanding with the plaintiff. So it's why people are one bag of bangarang in another case, you know? Because again, me see it with Spice, now me I see it with Mavado. Among whole heap of other artists, it don't look good for VP Records. Me can't go run a corner. Me don't know the intricacies of all the agreements and the non-agreement or what have you, or certain discussion and things that people agree upon. But it always just seems to look like, say, boy, VP in it just don't look good. Just the image of them don't look good in the acts or certain things. You get what I say, people? Alright, so VP look like so them a try throw themselves out of the mix and throw Mavado under the bus, so that him can stomach the whole life problem. You understand what I say, people? That it look like. See, I'm going to continue reading and finish this up. Uganda, while performance sufficient to suggest some alleged understanding, does not show that Brooks agreed to be bound by the performance agreement or the understanding was with plaintiff. Plaintiff's argument concerning representatives of actual authority are not supported by the performance agreement itself. They argued. The Gully Side artist attorney also argued that were also genuine issues of material fact, including the failure of the plaintiff to perform any of his obligation under the agreement, which precludes him from bringing a breach of contract claim as a matter of law. Among other failures, plaintiff admitted at his disposition that he did not make payments for travel or pay the balance of the deposit fee by November 1st, 2012. The date these payments must have been paid pursuant to the performance agreement. By plaintiff's own testimony and other documents produced in this matter, such monies were allegedly paid over 5 weeks late, the attorneys noted. The record also shows that the plaintiff failed to properly obtain travel visas and failed to make other payments, both required under the performance agreement. This agreement provides that if the deposit schedule is not met, the contract is void, they added. The attorney argued as well that the fact that the December 29, 2012 show did not take place was not a breach of performance agreement, but the Ugandans' failure to meet the deposit schedule voided the performance agreement and Mavado's obligation. So I guess the counter argument in Mavado's defense, based on what I read here and my understanding gathered, is that them did have a deadline to pay the rest of the balance, and they did not do so. You understand what I say? Therefore, that threw them into an automatic breach of the contract agreed upon. Tell me if it makes sense. See, the lawyer also said that they were conditions beyond Mavado's control pursuant to the terms of performance agreement, namely that the show Brooks would have been coming from was cancelled due to a third party's fraudulent conduct, which created a security risk for Brooks. Thus, there was no breach by Brooks. Additionally, even if Brooks had been bound by the performance agreement, there is no evidence that Brooks did not make every endeavor to furnish the performance within 120 days. Plaintiff has failed to demonstrate that there was an agreed upon renegotiation as to all aspects of the performance, the defense said. Plaintiff has also failed to prove that plaintiff all allegedly renegotiated terms as inter alia. Plaintiff failed. These are, of course, people, just bear with me here. These are, of course, court jargons and terms. So bear with me here. I do the best I can. Sound good and very interesting. Plaintiff failed to respond for weeks on end to timely provide certain consideration and to obtain travel visas while the parties were trying to work out a rescheduled date, it added. With respect to Akira's statement that Mavado knew that he had mortgaged properties in order to stage the show, the artist's lawyers said that the plaintiff had failed to produce competent evidence connecting alleged expenditures to expenses of putting on the concert, or that was plaintiff's loss. Additionally, plaintiffs cannot recover any damages related to the alleged properties that plaintiff's principal mortgage. Plaintiffs has no standing on even asserts such alleged damage, nor could such alleged damages have a sufficient causal nexus to the alleged events to be sufficiently foreseeable. They noted by deep the extent to the extent plaintiffs is including alleged lost profits that numbered, such profits are merely speculative and are also not recoverable. There must be a showing that the particular damage were fairly within the contemplation of the parties to the contract at the time it was made. Courts are hesitant to award lost profits to a new business because when a business is just starting, such profits are especially speculative and difficult to prove. They noted plaintiff, which was less than 2 years old at the time, had literally never promoted any show. Had literally never promoted another show. Even plaintiff's principal had admittedly only had one other prior show through a different entity, which either lost money or broke even. Plaintiff's principal had no background in the entertainment industry or as a show promoter, and only worked for a few months with one company to promote non-comparable smaller events. As such, any alleged lost profits are entirely speculative. Plaintiff cannot make out a prima facie claim or facie claim, and there are numerous issues of fact that warrant denial of plaintiff's anticipated motion. They added. So may I tell you, the Mavado people in my work apparently to make sure say, yo, we make everything very much clear that you can't come fling no lawsuit pan DJ. You see me as a people, and apparently based on the time and date sequence, a long time that's something you are going. Nonetheless, viewer subscribers, I go on all of the facts, I just go on the reading of the article. If you don't want to check it out, you can go up on Dancehall Mag. But this is just my few cents. It don't sound good. It also sound very much political and bangarang up and all of them look something with the music industry, dog. And them things are just kind of expose more at the inner workings of the corruption of Jamaican music industry. That's why you see enough artists when they just left and go do something with some totally different set of people who know business and know how to be fair. Tell me if that sound like it makes sense. Nonetheless, viewer subscribers, me hope and pray say everything iron out and ash out perfect and good for Mavado. Because you don't know a match go. Go decide the thing the people. And you don't know why artists them will say. You understand? But if the artists them wrong, then wrong. You see me? But it don't sound to me like the artist wrong, yes sir. And it sound like him have a very, very strong chance of getting the charges him acquitted or dropped. Because what it sound like as well is that the promoter don't have substantial and concrete evidence for provide certain documentation as it relates to the dates and time frame, feed the chronological order or sequence of how things happen, so that it can make sense. And maybe other documents where that support some of your claims. You understand me? But people, make sure you subscribe to the channel, like, comment, and share. Remember the other platform, Peaceful Ambition, the Wise Family 5, Akira's Journal, and Andre&Tiera World. It has been a pleasure. Big up on yourself. Thank you all for watching. I'm out.